All right. Hello, everyone, and welcome. We'll get started in just a minute. Well, hello, everyone. My name is Kathleen Klein, and welcome to DIYL's Back in the Courtroom, highlights from the last term, and a preview of SCOTUS's 21-22 docket with our featured and distinguished speaker, Chad Baroque. I would like to thank Alyssa Castro and the other members of the Politically Aware Committee for organizing the CLE today. I would also like to thank our featured speaker for taking time out of his incredibly busy schedule to present with us. I am going to go ahead and start with the introduction so you can know more about his background and understand why we so appreciate his lending his expertise for us today. Chad Baroque is a shareholder of the Dallas-based litigation firm of Johnson, Tobey & Baroque. Board certified in civil appellate law by the Texas Board of Legal Specialization. He has a wide range of experience in many high-profile matters for the U.S. Supreme Court and other state and federal appellate courts, representing clients in civil, criminal, and family law appeals. He's also a well-known author and speaker on constitutional-related issues, and his work has even been cited as legal authority in 3 published opinions. So I think you can see why we are so excited for his expertise today. But beyond just his legal work, he's also a leader in our community. And so we have many awards, and I want to briefly highlight a few of the things he's accomplished. He served on the State Board of Directors, the Executive Committee of the State Bar, and he's also was a chair of the Texas Bar College. In 2020, Chad was named to the Law Dragon 500, which annually recognizes the 500 leading lawyers in America, and has also been recognized since 2016 by Best Lawyers of America and won several awards within that. He received his BA in political science from the University of Minnesota and also his JD from the University of Minnesota Law School, where he was a Royal Stone Scholar. So as you can see, we are very appreciative of Chad Baroque lending his time today and cannot wait to hear about his analysis of the U.S. Supreme Court. I'm now going to turn things over to you, Chad, to get started.
Okay, great. Thank you very much. I'm happy to be with you all today, and thank you for the wonderful eulogy. I'm still here. No, it's very, very, very nice introduction. This is a little different from me, although I do speak, give Supreme Court updates like this. I always jokingly tell people, I was a college professor and a high school teacher for many years. I'm really more the person you ask what the Supreme Court did 150 years ago, as opposed to what it did last year. But I'm happy to be with you today. What I'm going to do is I'm going to start with just a few observations about where the court finished up last term, sort of conceptually, because I think that helps to inform where we're going. And then I'm going to talk about a dozen of the sort of blockbuster cases that seem to be coming up this term. And then I'm going to go back, and that'll be brief, obviously, but I'm just going to give you kind of a heads up as to what to expect. I don't have any great crystal ball to look into to predict how the court is going to rule. And then I'm going to circle back and go through and talk about maybe 20 or so of the more significant decisions from last term, just so you kind of know if there's anything in your practice area you may need to be aware of or something you want to learn more about. So we're going to start with last term, come to the upcoming term, and then circle back and spend most of our time talking about actual, CLE case opinions from last term. So, oops, let me see if I can make my PowerPoint go here. Yes, there we go. We started out with what a lot of people kind of jokingly called the Kumbaya Court. That lasted for a while. There were 25 unanimous decisions, despite what you read in the press about the fractured court. That was a 39% increase from last term. So an enormous number of unanimous decisions. And despite the fact that the court's workload actually was down, they actually accepted fewer cases. The numbers of decisions with what we think of as that clear Republican-Democrat partisan split actually declined from 8 to 6. So last term, the court only decided 6 cases where its decisions split on that partisan political divide. But that kind of comes with a caveat. How did we get to these broad majorities? By sidestepping a lot of hard questions. What happened, as we'll talk about, is in a lot of these cases, The court didn't decide everything that the parties wanted it to decide, but instead they peeled back and found much narrower ways to decide the cases. And as a result of that, we're able to build much broader majorities where deciding some of the other issues in the case might have split the court. So I guess the good news for appellate lawyers and for the rest of us, for litigators, is that there seems to be a lot of work for all of us to do filling in the undecided areas. By the end of the term, the Kumbaya Court was definitely gone. We got, as the court has done in the last few years, it sort of made a practice of releasing some of the really huge blockbuster decisions right at the end of the term. And some of those cases provoked the sharpest dissents. You can see here, Justice Kagan, for example, talking about the tragedy worked by the court in the Arizona voting restrictions case. Here is Justice Alito on Obamacare, calling that decision concocted and a flat out misstatement of the law. No one can fail to be impressed by the lengths this court has been willing to go to defend the ACA against all threats. Probably the sharpest dissent was Justice Gorsuch talking about administrative patent judge appointments, which we'll talk about in a few minutes. You can see this one too, short of summoning ghosts and spirits. How are we to know what those in a past Congress might think about a question they never expressed a view on? So pretty sharp dissents. For those of us, and then Justice Alito concurring but complaining of the failure to overturn employment division. This decision might as well be written on the dissolving paper sold in magic shops. So really sharp dissents, continuing the practice going back a little over a decade of sniping at each other in the dissents in the sharpest possible language. Those of us who teach about the court and follow the court, I think most of us find this trend disturbing. It does not do anything to build respect for the court as an institution, but it seems to be here to stay. One other thing about the court that I thought you might find interesting is just to see who's active during argument. That's very interesting. Who, and by active, generally that means asking questions. And you can see right at the top of the list, at the bottom of the list, I should say, no surprise, Justice Thomas. And I should say a word here in defense of Justice Thomas in oral argument. I think a lot of people suffer under some misconceptions about why he's well known for not asking questions during argument. He's had entire terms where he hasn't asked a single question. And people sometimes jump to some conclusions about that. His position on that actually is pretty defensible, I think, particularly for those of us who swim in these waters every day. Justice Thomas just believes that in the end, it's the party's case, and the parties have spent a lot of time and presumably a lot of money getting their case to the Supreme Court, and they should be allowed to tell the court what they want to tell the court or what they think is important. I don't know that I agree with that 100%, but I think it's a perfectly reasonable and defensible position. I've certainly had arguments where the court took my entire argument with questions, and that is frustrating for the litigants. They feel as though their counsel hasn't been heard in those cases. So anyway, he's at the bottom, not surprisingly, Chief Justice Roberts, Alito, Gorsuch, Kavanaugh. But then, somewhat surprisingly to some folks, we get to the top, and at the very top is our newest justice. So certainly not sitting in the back benches and biding her time as the junior most justice. She jumped right in and was a very active questioner during oral argument. So just some thoughts. Those are just some sort of thoughts about where we were, this idea of broad consensus, narrow decisions. We'll see if that continues into the next term. So here are some of the cases that I think are kind of interesting, and a lot of them you will see are close, either from Texas or have substantial Texas ties. Ramirez versus Collier, some of you may know Seth Kretzer down in Houston. This is one that Seth is going to argue, I think, just in a couple of weeks. This is a Texas death row inmate who he wants his pastor present at the execution, but he actually wants the pastor to lay hands on him as he dies. The state of Texas said yes to the attendance, but no to the hand laying. And the petitioner is arguing that this burdens his free exercise rights. So we're going to get a decision on that. That will be a very interesting free exercise decision from the court. City of Austin, another case actually out of Texas versus Reagan National Advertising. This one, again, is First Amendment, but this one is speech related. This is an Austin ordinance that distinguishes between signs that are on premises, which can be digitized, and those that are off premises, which cannot. And the question is that an unconstitutional content-based regulation under the speech clause of the First Amendment? Another speech case out of Texas that a lot of entities are watching very closely, including the state bar, is Houston Community College versus Wilson. This is a trustee of Houston Community College who was censured by his colleagues for controversial statements that he made. And the Fifth Circuit ruled in his favor, saying attaching any adverse consequence to his exercise of his free speech right violated the First Amendment. Now, those of you who have paid any attention to state bar politics over the last 18 months, or really those of you who are Texas lawyers who have not been under a rock for the last 18 months, know that the state bar faced a tremendous controversy over public remarks on Facebook made by its past president. And this case obviously factored very heavily in how the board of directors at the bar approached that, because the prevailing precedent of the Fifth Circuit said that absolutely nothing could be done, not even just a statement of reprimand or censure by the board. So this case is going to be very, very important for governmental and quasi-governmental entities as they grapple with those types of issues. FEC versus Ted Cruz for Senate. Here we're going to get another ruling. This is part of an ongoing national discussion. It's taking place certainly in all three branches of government about political fundraising and campaign finance ever since Citizens United, very controversial decision by the Supreme Court. This one asks whether federal election laws that impose restrictions on candidates when they're repaying their own personal loans to their campaigns violate their First Amendment rights of free expression. So we're going to get, again, another substantial campaign finance decision. If it goes in favor of Ted Cruz for Senate, we're going to see, I think, yet again, this expansion of the idea that all sorts of spending in campaign finance are protected under the First Amendment. Cummings versus Premier Rehab in Keller, case out of the DFW area. Are the compensatory damages provisions under Title VI of the Civil Rights Act of 1964, do those provisions allow compensation for emotional distress? Very closely related case, CVS Pharmacy versus Doe. Does the Rehabilitation Act permit a disparate impact cause of action for plaintiffs alleging disability discrimination? We got a decision on disparate impact claims in the housing context out of another Dallas case about 5 years ago. And so now we're going to get a decision under the Rehabilitation Act with respect to disparate impact claims for disability discrimination. Hughes versus Northwestern University. This is one that's maybe flying a little bit under the radar, but there's sort of a, here's what the case is about, and here's what the case is really about. The case on its face is about what you have to plead to allege an ERISA claim. But a lot of people fear, a lot of plaintiffs' lawyers fear, that what this case really is about is a sort of sneak attack to try and get some federal law out of the Supreme Court, heightening the pleading standards for plaintiffs generally in civil rights cases before they're able to obtain any discovery. So the plaintiffs' bar, particularly the employment and civil rights bar, is watching this case very, very closely with a very nervous eye about how it may affect federal pleadings requirements in those areas. 3 or 4 more I just want to mention. Again, you'd kind of have to be living under a rock not to know that the court is going to hear some abortion cases this term. We all know, as a result of recent media coverage, that the court has set an expedited schedule on the Texas case. So we're going to get a ruling on that. It's set to go alongside the already set Mississippi case. And of course, the Texas case is very different in its enforcement mechanism, but the Mississippi case, which prohibits abortion after 15 weeks, could and likely will put Roe right in the crosshairs. Roe may be on the line in that case. Now, that's not to say that there aren't plenty of ways the court could decide that case without really jettisoning Roe entirely, but it's also quite possible that they might view that as an opportunity to mount a full-on assault on Roe. We'll just have to see which direction they go. The court certainly had opportunities to do that before, and in the days when Justices O'Connor and then later Justice Kennedy constituted the swing vote, they always dialed that back and decided the cases on narrower grounds. Thompson v. Clark, this is kind of an interesting question. Can a person sue for malicious prosecution where the charges are dropped? There is Supreme Court precedent suggesting that a conviction must be overturned before you can sue for malicious prosecution. But what about if the prosecutor brings the charges and then dismisses them without any conviction? So that should be rather interesting. And then we've got the Boston Marathon bombing case. Taken a while, obviously, to get to the Supreme Court, but this also is a very interesting one. The defense wanted the jurors to be asked what they had seen and heard about the case and what they knew about the case, and the judge refused to do that. The judge instead asked the jurors only if they had formed any opinion about the case and whether they felt they could serve as unbiased jurors. This was a really difficult case to pick the jury. It took over 3 weeks. The defense filed 4 separate venue transfer motions, all of which were overturned. So you can imagine how reluctant the court is going to be, but it presents a pretty important question for criminal defense lawyers operating in federal court in terms of jury selection. Okay, New York rifle and pistol. Here is another Second Amendment case. Really just almost shocking when you think about it. We went so long, nearly a century, without any Second Amendment case being decided by the United States Supreme Court. And now here is, I believe, our 3rd or 4th in a decade. So this one concerns New York's law restricting concealed weapons outside the home to people who can make a showing that it's necessary for self-defense. The Supreme Court's going to decide if that statute violates the Second Amendment. Carson v. Macon, this is another one, a very interesting free exercise case. Maine has a number of areas that are so rural that they just can't support public schools. There's no public education available for kids in the remote areas of Maine. And so in those areas, the legislature earmarks funds for the parents, provides funding for those rural parents to be able to send their kids to the closest private schools. But there is a restriction. Grounded in the First Amendment, the state will not give them the money to send their children to parochial schools. It can't be any religious affiliated school. And of course, the state is doing that, believing it is acting consistent with the Establishment Clause of the First Amendment. But these parents are suing, saying that you are violating our free exercise rights by placing that restriction on the funding. So we're going to get another decision on the scope of the free exercise clause in the sort of school voucher context. So that's just sort of a preview of what I think are some of the more interesting cases the court is going to decide. One thing you will note is that we're not talking about any or almost no business cases. And that's something that's notable about the court's term. It's pretty heavy on what we would think of as sort of constitutional and social cases, and pretty light on what we would think of as business cases. And that's a little bit different from most years. So I want to take a look back now at about 15 of the really important and interesting decisions we got out of the court this past term. And I don't think there's anything more timely or interesting than the court's COVID opinions. And really there were 2 of them. And they kind of, well, I was about to say they span the pandemic. The first time I gave a recap of last term, I thought they spanned the pandemic. Turned out not so much. It's still with us. Back in I gave this just in that lovely 3-week window when we all thought the vaccine was going to wipe this thing out in July and we were done with it. I think it's very interesting, the refinement in the court's thinking about closure orders as the pandemic progressed and we learned more about COVID-19. The first ruling came down in May 2020. It was on a request for emergency injunctive relief. Now you have to put yourself back in that time and place. Remember, when COVID first hit, we got these just blanket shutdown orders across most of the country. And there were almost no exceptions at all, other than for just like the most vital emergency provisions, providers, folks that provide emergency services like hospitals, for example. Pretty much everybody was shut down and told to go home. And we knew very little about COVID, right? We were all terrified we were going to catch it by surface contact, when it turns out that was probably not too likely. It was much more likely to be spread by airborne means. But, everyone was scrambling, trying to figure out how to get a handle on this. And some churches in California sought emergency injunctive relief from the Supreme Court. And in a 5-4 decision with Chief Justice Roberts siding with the liberals, the court rejected that request and cited the broad executive emergency powers traditionally accorded to the executive branch to address any public health care crisis. And they pointed back to a decision about 100 years ago and said, look, we have the Jacobson decision. We've always been given probably our greatest deference to the executive branch in situations like this. We're not going to come in and second guess executive officials trying to deal with the early days of a pandemic when they know very little about it and what will be effective to address it. And we're certainly not going to do that on a request for emergency injunctive relief where our record is at best incomplete. So they reject that request. The other thing they note is, and I think this is important when we talk about the subsequent decision, they say, look, the churches aren't being singled out here. Everybody's going home. They're just subject to an order that everyone else is subject to. They're abiding by the same restrictions everyone else is abiding by, so relief denied. Then we circle back a year later, and New York is restricting the number of people that can attend in-person religious services. They're not shutting down houses of worship. They're saying you can only have this many people there. And the Supreme Court this time flip-flops and says, no, this one, not so much. We're going to, oh, and by the way, I should take back what I said. It was that the decision in May 2020 was not a 5-4 decision. I'm sorry, it was a per curiam decision. And then Chief Justice Roberts actually wrote a concurring opinion that was the only opinion in the case. So in New York now, we do get in the New York case, I believe it is a 5-4 split. That one, Chief Justice Roberts sides with the liberals and it's the 5 conservatives. And there was a lot of talk, a lot of people interpreted this either this was all about the change in the court, because of course we lost a liberal justice and gained a conservative justice. So there were a lot of people who just looked at it and said, well, that's just the new justice. And there were a lot of people who looked at it and said, aha, we told you all along those closure orders were illegitimate, never should have happened. This has been wrong for a year. I really don't think either of those probably is a correct interpretation of the court's decision in the New York case. You have to remember a couple of things about the New York case. Number one, it triggered strict scrutiny, because this one is directed at churches, okay, as opposed to the earlier orders that were blanket orders. The court was looking at the original case in California, probably using the rational basis standard, which is the lowest standard of review. In New York, it's using strict scrutiny, which is the highest standard of review. The second thing that's very different is that this one singles out churches. This isn't a blanket order. This order actually says you can have as many people as you want in a Home Depot or a Best Buy, but there's going to be a limit on the number of people you can have in a house of worship. And the court says, no, we're not going to express any opinion on these orders in general, but we're pretty doggone sure you can't single out a church for harsher treatment under the First Amendment. That we're pretty much sort of sure of. So they revisit the California decision and they grant relief, saying you can't just bar indoor worship services and you can't single churches out for limitations on the number of people who attend. That's the New York case. They go back in the California case and revisit and say you can't just bar indoor worship services anymore. But in California, they do leave in place a number of restrictions. There are restrictions on singing and chanting. There are capacity limitations that are across the board as opposed to directed at houses of worship, and the court leaves some of those in place. So you can see, I think the lesson here from these cases is this. And one of our justices in Texas made this point very well in one of the Supreme Court of Texas COVID opinions, saying how much deference we give the executive branch does depend on timing. We're going to logically give more deference in the earliest days of a pandemic when we don't know what measures may be effective than we are in the later stages where we know, for example, that we can slow it by social distancing. We can slow it dramatically by people wearing masks. We have a vaccine available that will slow it or control the effects, et cetera, et cetera. And he said, that's going to affect the calculus for us when we decide. It's not just blanket deference across the board. It does depend factually on where we are. Okay, my favorite case from the term. this is the BL case, the school case. And I'll explain to you why it's my favorite case in a minute. This is a student who posts terrible messages about the school cheerleading program on social media from her own bedroom in her parents' home. She's a member of the cheerleading team. She doesn't like the coach. She doesn't like the way the program's being run. And she just says some pretty horrible things. Imagine all the bad words and horrible things that a teenager might say. Well, we get some pretty interesting questions in this case. And one of them is one that has circled the court for some time, which is this idea of, can the school regulate speech that occurs entirely off campus and not at a school event? Right. So many of us, this was in my hip hop case, which some of you may be familiar with. Can a school discipline speech that occurs in a private residence? And as I've had people ask me, what's the big deal? And I say, here's the big deal. As a parent, my kids are all grown now, but when they were in the house, I always sort of assumed that as long as they weren't breaking a law, I was the final decision maker on what went on in my house. I was the final disciplinary authority on what my kids did in their bedroom, as long as they weren't breaking the law. But what happened was the circuits around the country really split on this. They were really divided over the school's authority to regulate off-campus speech. In this case, the Court of Appeals, the circuit court, held that a school can never discipline off-campus speech that other than school activities. The court said, look, if you're on school premises or if you're attending a school event off school grounds, yes, that's the limit of the school's disciplinary authority. And the Supreme Court comes along and says, well, we just think that goes too far. They say there have to be times when a school has a legitimate interest, either because of disruption, the speech is being directed into the school for disruptive purposes, which of course is the disruption is the big test under Tinker versus Des Moines, which you all probably remember from law school. There may be situations where a student or a teacher is being harassed. There may be instances of bullying. All of those things we think may justify school authorities imposing discipline. So we think the circuit court went too far in saying never. But we also think that in this case, the school lacked any authority to discipline the speech. This young woman wasn't just, there was no evidence of disruption in the school. There was no evidence that the cheerleading coach felt harassed or threatened, that there was no bullying. This was just unpopular expression. And not just that, the court went on to say, this really is her community. When we think of political expression in our communities, this is her equivalent of that. So what you did here was punish her for unpopular speech about her community. And that is just at the core, at the very heart of what the First Amendment is supposed to protect and prevent. So they say, we'll decide the parameters for another day. We're not going to talk about the reach of the school or different, but we're just going to say the circuit court went too far, but you can't discipline this speech because it is protected under the First Amendment. Justice Thomas, of course, dissents because Justice Thomas has a theory that the schools essentially, he doesn't believe that the students really have any rights in the school environment, at least not to free speech, and that the school pretty much has free rein. I say, by the way, the reason it's my favorite case is, you may not realize this, but it is the first speech case, that a student has won in the United States Supreme Court since Tinker in the late 1960s. They've lost every one between then and now. So it was a welcome change of pace. All right, Fulton versus City of Philadelphia, another case that people were watching because it was about one thing, but really about another. Employment Division versus Smith was an opinion written by Justice Scalia a couple of decades ago, in which he wrote for a court majority that a neutral law of general applicability cannot be challenged for failing to allow religious exemptions. So in other words, if the law, so long as the law is neutral on its face, it doesn't go after religion, and so long as it applies equally to everyone, there is no exemption for religious institutions. Okay, you can include religious institutions within the scope of a neutral law of general applicability. So here's a case where we've got a religious-backed foster care agency that won't provide services to same-sex couples. The city has an anti-discrimination policy, so the city cuts its funding. Says you can't have city money because we have an anti-discrimination policy. The Supreme Court unanimously holds that this violates the First Amendment. But this is one of those broad majority narrow opinions. It is an exceptionally narrow opinion and completely sidesteps the question everyone expected to be decided, which is employment division versus Smith still good law? It's a raging debate about whether that should be overturned. And what the court says here is, look, here's the narrow ground we're going to decide it on. You have other exemptions, Philadelphia. It's not a generally applicable law. It doesn't fall within employment division versus Smith because while it may be neutral, but it's not a law of general applicability. If you're going to give other folks exemptions on other grounds, now you have to give religious exemptions too. It's an either or. Either everybody gets it or you can't choose and pick in granting the exemption. So very, very, very narrow opinion. Justices Barrett, Kavanaugh, and Breyer concur to express their belief that Smith should be reaffirmed and not overruled. Justices Alito, Thomas, and Gorsuch concur and say that employment division versus Smith should be overruled. So you can see we've got a 3-3 split and we don't know where the others fall. Okay, Democratic National Committee, this is the Arizona case. You've got an Arizona law that prohibits the counting of any in-person ballot cast on election day outside your home precinct. On election day, you have to vote in your own precinct or your ballot gets tossed. And the claim is that they've intentionally understaffed minority areas. That's what the complaint is in the lawsuit, is that, yeah, they're making you vote in your home district and then they're not putting sufficient polling places in minority, in what we would call minority majority districts. There's also a limit on who can handle early voting ballots. It's restricted to poll workers, family members, and caregivers. That's it. Anybody else brings in that ballot, we toss it in the trash, right? The Ninth Circuit takes this thing on bonk and says it's a clear violation of the Voting Rights Act. Supreme Court says, we don't see a substantial effect on the openness of the election, so therefore we're going to reverse. This one is 6-3 on partisan political lines and provokes some pretty bitter dissenting language. Taylor v. Riojas, however you say that. I'd have to get my wife in here and ask her. I try to make a practice of not butchering the Spanish language, which is a beautiful language when spoken by everyone but me. This is a big case. This is a case that affects qualified immunity. And, you know, there's and this is developing. We're going to see what kind of legs this decision has, what kind of scope it really has, but it at least suggests some peel back in qualified immunity. This is a case where the allegation is that the conditions are just deplorable, just utterly deplorable. And there's been this idea among a lot of the lower federal courts that, look, you have to show me an directly on point US Supreme Court decision to overcome qualified immunity. So if the Supreme Court has not ruled that keeping an inmate in these filthy, dangerous, and deplorable conditions overcomes qualified immunity, then you don't get there. And the Supreme Court says, no, we're not going to take it quite that far. This is one where any reasonable correctional officer in America would have known that this violated the 8th Amendment to the Constitution, and therefore we're going to let you jump over qualified immunity. Okay, Ford Motor Company, let's change pace and talk a little bit about business and personal jurisdiction. This brings back, everybody remember International Shoe, another oldie but goodie from our first year of law school that most of us then quickly put out of our memory. But this is International Shoe revisited, and a very rare win in the United States Supreme Court for consumers, and a very rare expansion by the court in recent decades of jurisdiction. This is one where Ford sells the car in one state and the purchaser moves to another state and sues for a product defect in that state. So Ford looks at this and says, look, we didn't do anything in that state. We didn't build it there. We didn't market it there. We didn't sell it there. I mean, nothing. That person cannot sue us under, and by the way, this is under general jurisdiction. They should not be able to sue us. A specific jurisdiction. And so the argument being that if you're going to sue us under specific jurisdiction, there ought to be some link to your specific transaction. That's really what Ford is saying. Yeah, we understand the rules may be different for general jurisdiction, but if you're suing us under specific jurisdiction, there ought to be a specific link between the consumer's transaction and that state. Them buying it here and moving there should not get us on the hook. And the court says, no, that's not right. There's no causal link to the claim that's required. Here, Ford, you have purposely availed yourself of the benefits of systematically serving markets in those states. You know quite well that people cross state lines to get deals on cars. You have, you do this all the time. You have a system in place to accomplish this. You know, for example, that people in rural Western Wisconsin are going to drive across the border 20 minutes into Minneapolis to buy their Fords. You have purposely availed yourself of the benefit of serving that market, and therefore you are subject to suit here. One final note on this case. So I think this is a really interesting case in a variety of respects, certainly a massive expansion of jurisdiction. And Dan Geiser, we spoke on this a couple months ago for the state bar, and he raised a really interesting point. He said, this almost looks like the Supreme Court not just exercising its jurisprudential role, but sort of exercising its role as the senior decision maker in a branch of government. It's almost like they're making a governmental decision here that just says, look, you have a local Ford dealership. You have Ford dealerships all across every state. The fact that you chose to drive across the border to buy your Ford really shouldn't make a difference. It just seems like a company like Ford that clearly is intending and is selling its products in 50 states and every territory ought to be subject to suit in 50 states and every territory. All right. Uzabionum, got it, versus Przewski. This is one where the plaintiffs are handing out religious literature in what the college calls its free speech zone. I love the concept of a college having something it calls a free speech zone. I naively have thought most of my life that an entire college is a free speech zone, but that's just me. A number of students complain about this religious literature being distributed, and the school tells them they have to stop. So what happens is the plaintiffs file suit, and then the college voluntarily says, okay, never mind, you can start up again, and says, move to dismiss for lack of standing because we stopped. And the Supreme Court says, no, you can get Article 3 standing off nominal damages, which is what they had, and therefore, even though there's no standing in terms of no need for injunctive relief, their request, their entitlement to nominal damages is enough to support standing under Article 3, even though you have stopped the activity that would justify or require injunctive relief. McKesson v. Doe, this one's, I think, really, this is such an interesting case. And this dispute is going on in a variety of places around the country, including in Dallas, but this one certainly reached the Supreme Court very quickly. McKesson is the guy who organized the protest outside police headquarters in Louisiana. Somebody throws a rock-like object at one of the officers and really injures him very, very badly. And they sue McKesson for organizing the protest. So the question is, can you sue the protest organizer if the protest gets out of hand? And the district court tosses it out under state tort law, and the First Amendment says, no, you can't sue him because some lunatic threw a rock or something else. The Fifth Circuit reverses and then deadlocks on rehearing. And the Supreme Court says, look, this case turns on a really important and unresolved issue of state tort law. You've got to decide this under Louisiana tort law, and it's a critically important issue for Louisiana tort law. You need to send this one back. You've got to certify it to the Louisiana Supreme Court. And so that issue arises in the federal courts more often than you might think when you run into these unresolved areas of state law. The federal courts generally make what we call an eerie guess. But when it's this important, the Supreme Court says, no guessing, send it out there and have them decide. Americans for Prosperity versus Bunta. This is a California Attorney General rule that requires charitable organizations to disclose their major vendors. And the court strikes it down on First Amendment grounds, says, look, you're demanding information from tens of thousands of entities when only a handful of it is really necessary. What they're challenging here is nonprofit status. They want to see what folks, they're complaining about certain people getting nonprofit status. And the Supreme Court says this affects like just a handful of entities, and you've imposed this blanket rule on everyone in the state. So it's just way overbroad. I mean, you remember again, when we deal in these First Amendment areas, you've got to narrowly tailor whatever it is you're doing to suit the compelling governmental interest. And here you didn't do that. You may have a compelling governmental interest, but you're definitely not narrowly tailored. This one, again, is a 6-3 on partisan political grounds. NCAA versus Alston. NCAA rules prohibiting compensation violate federal antitrust law. That's why you see a kid from Dallas who's now able to sell his jersey rights as a freshman at Ohio State. So this is going to be very interesting. This one isn't so interesting for the holding as it is for the effects. We're going to see what type of effect this has on college athletics in the long term. Goldman Sachs. The Arkansas teacher retirement system. This is another one that started out as a blockbuster. Everybody thought, oh, this is going to be a huge case. Ended with a very narrow ruling. But the big question here is, how do you bring a class action in the securities context? And you've got these earlier cases that talk about a rebuttable presumption of reliance on all statements in the marketplace. So anything that goes out there about a security, we're going to get this rebuttable presumption of reliance on all of it. But the question then becomes like, okay, what if it's not a specific statement about the security, but just sort of generic and boilerplate statements like our company, we always follow the law. And the court says, look, we're not going to make any big picture decisions here. We are going to reverse and say, when deciding these price impact claims, the court can take into account that the statement is very generic. But we're not sure that happened here. We're going to send it back to the Second Circuit and let you decide if the proper analysis actually took place in this case. Penn East Pipeline. This is one, it's always fun when you read a decision in 2021 and a litigant loses because of something they did in the 1780s. That doesn't happen. You don't get that opportunity very often, but this is one where that does occur. The question in this case, sort of the broad question is, can a pipeline developer take advantage of the government's power of eminent domain to build a pipeline? So in other words, here comes a private pipeline developer cruising along and needs to take somebody's property, and that person won't sell it. Are they able to condemn it? Can they use that eminent domain governmental power to seize the property and forge ahead with the pipeline? And in a 5-4 opinion, the Supreme Court says yes. The state's argument, of course, is we have immunity. You can't sue us for this. And the court says, well, you surrendered that immunity from the federal eminent domain power when you ratified the Constitution, right? I mean, that power is in the Constitution as being given to the national government. So when you chose to ratify the Constitution, you surrendered the immunity you otherwise would have had in the eminent domain context. Okay, that's number one. So again, litigant, state of New Jersey, what you did in the 1780s costs you your claim in the 2020s. And then they say, look, the Natural Gas Act, which is a validly enacted piece of federal legislation, delegates the federal eminent domain power to private entities. The federal government can do that. Federal government can delegate its power to condemn private property, and it's done so validly here. Probably the most interesting thing, I mean, this is going to be clearly a big case in terms of development, right? I mean, this is a very, very important case for private development. But I think one of the things that's most interesting about it is if you look at the bottom, your 5 members of the majority are not necessarily who you might expect to see together in a majority, but this is a property rights case, and when we get out of those what I'll call hot button social issues and voting rights cases and those sorts of things, we tend to see a lot of these mix and match majorities on the court. So again, this is one that's certainly a little different than we're accustomed to seeing, but this is not at all unusual once we get outside those hot button areas. Okay, just a couple more. In fact, I'm going to go ahead and see 3 more. Okay, this one was painful in our house. The Cedar Point nursery case. My wife's parents were migrant farm workers. Her father worked alongside Cesar Chavez in the struggle to obtain rights for those folks. My wife actually grew up in the same town as where Cesar Chavez lived. Delano, California. And this was one of his major legislative accomplishments. This is a California regulation that I have no idea why there are those typos in the PowerPoint slide, but this is a California regulation that gives labor unions the right to access an agricultural employer's properties to solicit union members. And the rationale was simple. There was just no other way for them to do that, at least back then. It might be a little bit different today, but back then they really needed access to the property to talk to these folks. So California passed a law back in the 70s saying that the unions could physically enter the property and occupy it for 3 hours each day, 120 days out of the year, for the purpose of talking to people about joining the union. And this is another 6-3 political lines decision. The majority says this is a per se physical taking that violates the Fifth Amendment. You're taking away a property owner's right to control who comes onto his or her property. And that's sort of the essence of property rights, correct? This idea of controlling, it's my property, I get to decide who stands on it. So the court views that as a taking under the Constitution. The dissent's complaint isn't with the takings analysis per se. They say, look, we've always distinguished between permanent and temporary takings, and we just don't think, a few people coming on in a sort of a transitory discussion role 3 hours a day, 120 days a year is enough to constitute a taking under the Constitution. We've held that more serious temporary takings, in our view, do not meet the constitutional taking requirements. So that's where the dissent is coming from, that we just think this falls under that line of sort of temporary takings cases that do not rise to the level of a constitutional taking. Okay, United States v. Arthrix. This is, and just funny that this would be the case that would provoke perhaps the most strident dissent, or the second most strident dissent of the term, but it's a case under the Appointments Clause of the Constitution. And there's a lesson from here. So this case concerns administrative patent judges. And these folks essentially make decisions in litigation. And so the question before the court is, because these folks are making final decisions on patents, are they the types of judicial officers who must be appointed under the provisions of the Constitution, appointed by the president, confirmed by the Senate, subject to lifetime appointment, et cetera, et cetera? And the court looks at this and says, well, these folks their decisions are effectively unreviewable. I mean, they are the final arbiter and they have tenure. So yes, it seems to us they are the type of people that you can't just appoint outside the Constitution. They are going to be, and you certainly can't have an administrative agency appointing them. They're going to have to be appointed under the provisions of the Constitution. Now, here's the key practice take away from this. If you have clients facing agency enforcement actions, federal agency enforcement actions, the first thing you want to look at is whether the judges, the agency judges who are deciding those cases, were validly appointed. This argument actually has had pretty strong success, repeated success in the federal court system. So again, if you're representing those sorts of folks, probably your first step is to see, okay, how was whoever is deciding the case appointed? And does that appointment meet the requirements of the Constitution? And then I think this is our last one, Transunion versus Ramirez. I'm going to give you 10 minutes back today or so. So this is a standing case. And unfortunately, the Supreme Court, when it comes to consumers this term, the Supreme Court giveth and the Supreme Court taketh away. This is a 5-4 win for the corporations against consumers under the Fair Credit Reporting Act. And again, a little bit of strange bedfellows here. This time it's Justice Thomas who crosses over and sides with the liberals in this case. So this is this poor guy. They ran a credit check on him, and his name comes up on a really bad list. His name pops up on that list of people that no one in America can do business with, says the federal government. It's a terrorist list. So hands off all of these folks. Well, it turns out that through some sort of error in the system, 8,000 other people also were placed on this list. We had 8,000 folks in America designated as don't do business with them because they are terrorists. And so they file a class action. Here's the problem. Some of these people actually were the subject of credit reports and some were not. In other words, they went on the list, and during the period they were on the list, some of them applied for credit or for whatever other reason, maybe employment. Those folks had their credit reports run, and they were reported to someone out there as actually being on the list. But a whole bunch of people were not. There were a whole bunch of people who were on the list, never applied for credit, never applied for a job, no credit report was ever run. So no one ever received a report naming them as being on that list before the error was discovered and they were removed. And so the question was, were you harmed just by being on the list, even if that was unreported? And remember, this type of false information under the Fair Credit Reporting Act is actionable. Right? It's actionable. There's a statutory action provided. And the Supreme Court says no, even when we have a federal statute that provides a remedy, you still have to show harm to meet the federal Article 3 standing requirement. If you can't show harm, even though you may fit into the remedy, you may meet the criteria for the statutory remedy, as a matter of constitutional standing under Article 3, you have to show some concrete harm in order to have standing and bring the lawsuit. So they say folks who were not reported don't have standing to sue. So that one is a win for the corporations. That, I think, is a pretty complete discussion. Unless there's anything else anyone wants me to address, I think we've talked about what I consider to be the major cases coming up. I think the key question this term probably is going to be, are we going to continue to see this trend of trying to cobble together broader majorities with far more narrow holdings, or are the types of cases we're seeing, because we have a very, as you can tell by the case summaries, we have a very different upcoming docket than the one we just saw, and it may simply not be possible to cobble together those types of majorities. The only thing I'll say in closing is that even the most veteran and the most scholarly court watchers, folks like the Erwin Chemerinsky's of the world, are telling people this is going to be one of the really extraordinary years in the history of the United States Supreme Court. So, grab some popcorn, buckle your seatbelt, and enjoy. Thank you.
Thank you so much, Chad. We really appreciate it. If you have any questions, you can put them in the Q&A. I believe the CLE code will be provided in the chat here shortly, and you will need to take that from the chat. A quick reminder that argument days for the Supreme Court are earlier on in the week. They're Monday, Tuesday, Wednesdays, and the calendar is posted on supremecourt.gov if you're interested to keep your eye on some of these cases. Thank you again, Chad. These are really interesting, and it does look like we have a lot coming down the pipe. The prior term and insights that you gave us, I think, are going to benefit all of our members, and we really appreciate everyone's time. Let us know if you have any questions. Otherwise, CLE has been posted in the chat for you to take and copy it. It will not be available afterwards, or you'll have to email one of us to get that. Thanks, guys. Looks like we don't have any questions because it was so thorough, and we really do appreciate your time.
Absolutely. Thanks.
I think Kathleen's might be frozen. Thanks, everyone.